This is Dan Schneider. On this Dan Schneider video interview, the topic is corporate personhood. Is it a good thing? What is the history behind it? And I have two experts that will guide us. The topic is corporate personhood. On the left, you will see Adam Winkler. On the right, Matt Rothschild. As I usually like to do, I want to give each of the men a few minutes to just introduce themselves, a little bit about their legal background and their positions on the subject at hand. So let me start with you, Adam, first. If you could just give a little bit of background biofiller on yourself.
Sure. Well, thanks for having me on the show, first and foremost. Always happy to come on and talk about such engaging issues. I'm a professor of law at UCLA School of Law. I teach constitutional law. I'm the author of a book on the Second Amendment called Gunfight, The Battle Over the Right to Bear Arms in America. And I am currently finishing up a book now that will be published next year called We the Corporations, the story of how American business gained their civil rights.
Okay, and on the left is Matt Rothschild. Matt, if you could give a little background about yourself.
Sure. I'm currently the executive director at the Wisconsin Democracy Campaign, a nonprofit based in Madison, Wisconsin, that looks at the role of money in politics. We try to expose that problem and advocate for solutions to that problem. Prior to joining the Wisconsin Democracy Campaign about a year and a half ago, I was for more than 30 years at the Progressive magazine, most of that time as editor and publisher. Prior to that, I worked for Ralph Nader in Washington, D.C. I'm not a lawyer. I am the son and grandson of a lawyer, and my three brothers are lawyers, so I kind of escaped that fate. But I have a great deal of interest in the law, and in fact, my father's law partner for many years in Chicago was Justice John Paul Stevens. So law is something in my blood, but not a credit that I have up on the wall. So there you go.
Okay, well, let me just open with a quote from the 19th century author Ambrose Bierce. You've probably both heard this before from his Devil's Dictionary, that a corporation is a noun, an ingenious device for obtaining individual profit without individual responsibility. And I know, having worked many years in mostly corporate America in low-level positions, I find that to be both funny but also quite true. Before we talk about corporate personhood, what is the general rationale in Western law for corporations, and how did the concept of corporate personhood then evolve out of that? So I don't know, Adam, if you want to start since you're the lawyer.
Sure, happy to talk about it. So the corporation is a device that goes back really to ancient Rome. We have evidence that the ancient Romans formed corporations first and foremost to avoid the business problems that came with partnerships. The idea of a partnership is that we each come together and we bring our assets together, but the assets always belong to the individual partners, not the partnership.
Yeah.
And anytime a partner died in ancient Roman law, you had to recreate the partnership. You had to rewrite your documents. You had to come to new agreements as to who was going to be involved. And this led to an incredible amount of chaos for businessmen in a nascent Roman economy. And so they started forming corporations, entities that could essentially hold property in their own name. That was the essential purpose. So that, because they could do that, when one of the partners or one of the investors or owners died or transferred their shares, the business could go on, and you wouldn't have to reorganize the whole thing like you had to do with a partnership. And that's the early origin of a corporation. And I think one of the things that's important is that it kind of triggers issues that we're still concerned about today, in the sense that what you see is that part of the idea of a corporation was that it would be perpetual. It would live forever, regardless of who formed it and the members that were in it. But also that it was designed to exercise rights. That is to say, it was designed to be able to hold property over that perpetual life and have a right to property that couldn't be taken away from it. And so there's an intriguing early history of corporations that ties into some of the very concerns about corporate power and corporate rights that we're concerned with here in the era of Citizens United and Hobby Lobby.
Matt, do you have a comment?
Well, to me, I mean, the crux of the question, I'm sure we're going to get to it soon, is what rights do corporations have outside the commercial realm, and whether they have rights that are enshrined in the Bill of Rights or the 14th Amendment, or whether their rights should be cordoned off into the commercial sphere. I mean, I have no problem with people forming corporations and then wanting that corporation to live beyond them, or to split property, or to split profits, or even to some extent shield liability, though I do think executives for corporations, if they are directly involved in something criminal, should be held responsible for that criminal behavior. But my real problem with corporate rights is, first of all, I don't believe the Bill of Rights were designed for corporations, and Justice Stevens in his dissent in Citizens United talks about that. I also think corporate rights are eating our democracy. That's the essential question.
Well, since we're all Americans, I'm probably 98% of this show will deal with American law. And as far as I know, as a layman, and guys can correct me, the first and most important case that established the idea of corporate personhood, that a corporation de facto is sort of a fictive human being in essence, was in 1819, Dartmouth versus Woodward. Maybe Matt, Adam rather, you may want to, I'm sure that's probably a seminal case. What was the crux there, and how has that affected all cases that have come after it?
Well, you're right that the Dartmouth College versus Woodward case was one of the most important cases in American constitutional history, and a very important case because it expands the rights of corporations. And it's something to point out, too, that while we think in terms these days, in terms of Citizens United and Hobby Lobby, as a sort of new controversy of corporations gaining constitutional rights, in fact, corporations have been pushing to gain constitutional protections since America's earliest days. And like you say, the Dartmouth College case that was decided in the 18-teens, just 20 years or so after the founding, was one of those early seminal cases. And what the Dartmouth College case held was that, at the time of corporations, it wasn't clear whether corporations were public or private. And in fact, they probably should be considered a hybrid that are both public and private. You need the government to create a corporation. You can't get that limited liability. You can't get that status as a person before the law. That is to say, someone who stands before the law can be sued and can sue and be sued in court of law, can have property rights, can form contracts. That idea of a corporate person. You couldn't do that without the state, so it was inherently a public enterprise. At the same time, it was staffed by private people, it was financed by private people, and it served for a private profit as well. And so the corporation was a mix of both a public entity and a private entity. And the Dartmouth College case was a case decided by the Supreme Court early on, where the court held that corporations were effectively private entities, not public entities. And that meant they were in the American system, where we have the government that has powers and individuals and private individuals who have rights. The corporations were on the private individual side. They had rights that they could exercise against the government, and were not themselves like, say, a city agency or government agency subject to complete state control.
It seems that's almost anathema to what's this American strain of individualism. When I think of other corporations, say here in North America, outside of U.S. purview, like the Hudson's Bay Company back even before the U.S. was formed, that they had almost godlike powers and control over their lands, to the point where they were probably more powerful than a lot of smaller nations. Why do you think that was the Dartmouth decision even in any way influenced by outside corporations? And did corporate personhood exist in any other nations before the U.S. declared it? Either of you.
Is that for me?
Either of you. Go ahead, Adam.
Go ahead. I have some ideas too. Well, corporate personhood is not something that developed in America. And in fact, before America was born, if you read Blackstone, written in the 1760s and 1770s, Blackstone had a whole section on corporations. And he makes clear some interesting things. One of the things he makes clear right at the get-go is that the idea of a corporation was to create a person, a legally recognized entity that could hold property in its own name for as long as it existed, that could form contracts in its own name, and it would be responsible for those contracts, and could sue and be sued in a court of law. Those are sort of the three core rights that Blackstone points out that corporations must have. This is even before America, and he says the idea of a corporation is to continue to keep rights on hand. So the idea of corporate personhood, I think, really has two ideas, and neither of them were born in America. One, so the corporation is an independent legal actor. It's not reducible to its members. Its legal obligations and duties and rights are different from the rights of its members, but yet, the second principle is that corporations do have at least some basic rights, such as rights of property, rights to sue and be sued in a court of law, and rights of contract, to be able to form contracts and to function. And that's what Blackstone said corporations were, even before the idea of corporate personhood was enshrined into the American Constitution.
Matt, go ahead.
It's interesting. If you look at our founders, Jefferson in particular, Jefferson warned almost 200 years ago that we must crush in its birth the aristocracy of our moneyed corporations. And I think, and Justice Stevens quoted that in a footnote in the Citizens United case. And I think it's an important point. This is the question, whether the power and rights of corporations transcend the limited sphere that Adam's talking about, which is the ability to hold property, sign contracts, be sued, or whether it's going to expand that and claim the rights that individual people have enshrined in the first 10 Bill of Rights amendments there, and also in succeeding ones like the 14th Amendment. And that's what's happened increasingly over the last, certainly since 1886, that's in the Santa Clara case, all the way through Citizens United, all the way through Hobby Lobby, even this accretion of rights, individual rights that are assumed now to be or granted by the courts, corporations, and this is an increasing problem for a democracy.
Yeah, and the odd thing that in 1819 was the Dartmouth case, and yet blacks, Native Americans, and women were not fully enfranchised as human beings, even though they were actual human beings, of the age of majority. And yet the country was creating these fictive entities. I would have to assume, though, that money was the driving factor, even 200 years ago, in this drive to get corporate personhood. Would that be correct?
Well, it's certainly correct. Increasingly, the corporations are seizing on these phantom constitutional rights that they're attaching to themselves because it helps them make profits and it ensures their property. So, and it aggrandizes their power. I mean, that's the essential issue. And, it's interesting. The 14th Amendment wasn't designed for corporations. That wasn't what it was about. But was for the 50 or 75 years after it came into being, it was used like 50 to 1 for corporations, not for, former slaves saying that their rights had been violated. This is according to Justice Hugo Black.
Adam, do you have a comment?
Well, I think that's right. I mean, I think what we've seen, there's been a sort of untold story of civil rights in America. Like we tell the stories for every school child about how people who were excluded from the promise of we the people at the time of the founding, people like blacks, other racial minorities, women, how they were kind of left out of that promise. Like they didn't get to vote on the Constitution, and they weren't protected by the rights that the Constitution guaranteed. And much of American history is the story of their battle and struggle to gain constitutional protections, to gain civil rights, and to gain equality before the law. But what we've also had, and it starts in 1809 in the Supreme Court, is really a civil rights movement for business corporations.
Yeah.
An effort to gain nearly all the constitutional protections that individuals have for corporations. And that's done specifically for the purpose of defeating government regulation. Government regulation of business activities and corporations, in the same way that you use constitutional rights if you're engaging, if you want to have intimate relations with someone and the government's trying to regulate those intimate relations, you're trying to seek autonomy, exclusion from those government regulations. Same thing for corporations. Although they're not seeking intimacy, they're seeking profits, and they use these constitutional rights to defeat regulation. And it's been a civil rights movement for corporations. It's been going on and is frankly in many ways more successful than the civil rights movements for women and for racial minorities.
And I've got to say that I think people who've been engaged in the civil rights movement for African Americans or for women or for gays and lesbians would be grossed out by the analogy of civil rights for corporations, because corporations haven't been oppressed like slaves were oppressed, African Americans were oppressed during Jim Crow, gays and lesbians were oppressed until very recently, before, and still oppressed socially, but not nearly as much as before. So the analogy is something that sticks in my throat, and I'm sure sticks in a lot of other people's throats. And I don't know if you mean that analogy, Adam, tongue-in-cheek, or whether you actually think it's a legitimate civil rights movement for corporations, but I do think that is one that raises my hackles.
Well, maybe I do it in part to raise a little hackles, but I think it actually just provides a framework for us to understand what's happened. It's not that I'm thinking it's a great thing that corporations have had a civil rights movement. I actually think that the civil rights movement for corporations has really gone way too far. And you're absolutely right that there are huge differences, not only between levels of oppression, but the kinds of individual dignity that's sought to be won by racial minorities and women in their civil rights movement. But and so I do say it to be somewhat provocative. But I think what we've basically seen is that if we think about what a civil rights movement is in part it's an effort to gain rights that you didn't otherwise have. And we've seen corporations do that. And if you go through the Constitution, you go through the Bill of Rights, and you go through the post Bill of Rights amendments to the Constitution protecting individuals, what we find is that with a few exceptions, corporations have gained nearly all of those constitutional rights and protections. And we might call that a civil rights movement or not, but we've seen a huge expansion of corporate rights under the Constitution.
Well, I'd only say that not every power grab is a civil rights movement. And what I see corporations doing increasingly is a power grab.
Well, let me. I want to move to the 20th century. Some cases there, but before I do, since we're talking about movements, I wanted to talk about the union movement, the labor movement, because if corporations are individuals that are employed, that are coming together as a group to be considered one entity legally, why has it would seem concomitant to that unions should be granted personhood as well. What is the difference legally, say, between unions versus a corporation then? And why don't unions have some of the same rights that a corporation does?
Well, in Citizens United, unions and corporations are treated quite equally. That unions and corporations can spend unlimited amounts of money as long as they're not coordinating with candidates to say we want to elect this candidate and not that candidate. But I'll defer to the lawyer in this conversation.
Well, you're absolutely right. There's no doubt about it. Actually, unions are in many ways considered persons before the law. They have legal standing, and they have many of the same rights that have been so controversial when they've been extended to corporations, such as Citizens United and rights of political speech. In fact, what we've seen actually through American history, at least over the last 20 years, through the 20th century, last 100 years, we've seen that there's almost been a lockstep between the official political rights of corporations and the political rights of unions. And in fact, the idea of PACs, political action committees, that are today so commonly dominated by corporations, were first devised and used by labor unions in the 1950s and 60s to organize and to become politically active. So there's often been similar treatment. The difference is that corporations have way more money at hand to use for politics than unions can really ever hope to have.
Yeah, and also there are things like right-to-work states and at-will states where people can opt out of unions, whereas if I'm making X amount of money for my corporation, I can't say, well, my department brought in this much, but I don't want it to go for that particular cause. Let me talk to two decades in the 20th century that I think are key. The first is obviously the 1930s with FDR. And again, I'm a layman, but wasn't one of the major controversies of that decade was Franklin Delano Roosevelt's attempt to stack the Supreme Court, and wasn't that based mostly on things his sort of anti-corporate crusade? I don't know if that's relevant, but could you maybe address that, Adam or Matt?
Go ahead, Ed.
Well, happy to. Yeah, well, look, Roosevelt undertook the most extensive regulation of corporate America in American history. And corporations did fight back. And in fact, the Supreme Court, at least until Roosevelt was able to seize control of the court by getting enough nominations to change its composition, what you had was the Supreme Court siding with corporate America and striking down these regulations. And actually, it's one of the interesting things I found in my research into sort of this long history of corporate rights is that the Supreme Court we often think of the Supreme Court as being liberal or conservative, but over the course of the American history, what we really find is that the Supreme Court has been very pro-business, and the court's approach to corporate rights, constantly expanding the rights of corporations throughout the 1800s, throughout the 1900s, and continuing to today, is in part a reflection of that the real power in the Supreme Court comes not from the left or the right, but comes from business, and that business forces have consistently been among the most powerful and persuasive in the Supreme Court. And those early New Deal cases, until Roosevelt was able to seize control of the court by appointing more New Dealers, were in some ways a reflection of that pro-business tilt.
And the pro-business tilt continues today. The Roberts Court very friendly to corporate interests. So, that continuity over time is something that I think those of us who oppose corporate power and corporate personhood want to see changed. And it's one reason why there's a fundamental move to amend the Constitution, because just hoping for a different Supreme Court justice here or Supreme Court justice there isn't going to solve the fundamental problem.
Yeah, I want to, in the next segment that we do, get into sort of the pros and cons of these attitudes and decisions. But I want to end this segment talking about three cases just briefly from the 70s, and then also, since you've mentioned it, the Citizens United case this century. But it seems to me, again, as a layman, that three very interesting cases in the 1970s expanded greatly corporate rights. And I only know a little bit about them, so maybe, Adam, you can expand. In 1970, there was the Ross versus Bernhardt case, and the basic amendment granted was the 17th right to a jury trial. In 1976, there was U.S. versus Martin Lennon, where Fifth Amendment right against double jeopardy was granted. And in 78 was Marshall v. Barlow, where the Fourth Amendment protection for Congress was granted. Was the 1970s a pivotal decade in the last century for the expansion of corporate rights, or were they just minor cases? It seems to me those are pretty three big rights granted.
Well, they are, and I think actually your question really highlights an important point that's often lost in the controversy over Citizens United, is that corporations have not only won rights like political speech rights in Citizens United and religious freedom rights in cases like Hobby Lobby, the things that have really taken over the headlines, but subtly and quietly, they've had this movement where they've really gained so many of their constitutional protections. And some of the cases that you point out are cases like Fourth Amendment cases against unreasonable searches and seizures. I think in some ways, though, that the Fourth Amendment cases that you point out highlight maybe in some ways what might be the right way to think about corporations and corporate rights, which is that in those cases, the Supreme Court holds that corporations do have rights of privacy and the government just can't come anytime without a warrant in any circumstance and search your business records and your business facilities. But they also crafted many exceptions and basically special rules for corporations that allow government more leeway in conducting searches of government property. They're covered by the Fourth Amendment, but they're not covered in precisely the same way that ordinary individuals are covered. And so I think those cases might be an indication of a good way to think about corporate rights. Yes, corporations have many of our constitutional protections, but to the extent they have them, they don't have them in necessarily the same exact way as individuals do.
And the effort to apply the exact same parallel set of rights, individual rights to corporate rights, is really at the heart of the problem here, both as regards to the expansion of the First Amendment rights in Citizens United and the Hobby Lobby, but also these Fourth Amendment rights to inspections, OSHA inspections, for instance, or there was a Dow Chemical case where the government was flying planes, EPA was flying planes over the Dow Chemical plant. Actually, Dow lost that case because it was considered to be, basically an open field that anybody could look at. But this effort to expand not just First Amendment rights, but Fourth Amendment rights and Fifth Amendment rights to corporations and make them identical is really a crucial problem. The Bill of Rights, our amendments were not designed for corporations and shouldn't be applied 100% to corporations. And I think that's what those of us who are so fearful of corporate power and understand how much power corporations wield not only over our economy these days, but crucially over our democracy and our political system are so worried about.
Yeah, let me just end this segment, and I'll ask you, Matt, since you brought it up a couple of times, just to summarize the more recent case of Citizens United, because that seems to have been what a lot of people say is the final latch with the floodgates. Now money is in play, and that seems to be the burr under a lot of people's saddles. So, Matt, if you want to just briefly summarize that and your position maybe on it.
Sure. Well, this is kind of Citizens United is kind of the son of Buckley versus Vallejo, which was the big 1976 case, which said, essentially that money is speech. Now, Citizens United was in 2010, and it said in a 5-4 ruling written by Justice Kennedy that corporations and unions and other associations could spend unlimited amounts to support a candidate of their choice or to trash a candidate they didn't like. And it was based on two really false premises, amazingly naive statements if they were serious about them. And let me just read these two sentences out of Citizens United. Sentence number 1, independent expenditures, including those made by corporations, do not give rise to corruption or the appearance of corruption. And the second sentence is, the appearance of influence or access, furthermore, will not cause the electorate to lose faith in our democracy. Now, when I read these out loud to people, half the people laugh because they wonder what planet the justices are on, because people are already losing faith in our democracy. And people understand, if you're a corporation and you're going to spend, say you're ExxonMobil, and you know that Russ Feingold opposes ExxonMobil and climate change, and you want to spend $200 million to defeat Russ Feingold running for Senate again here in Wisconsin right now, and you do that and you defeat him and you keep Ron Johnson, Republican, in the Senate, to think that ExxonMobil's not going to have some influence over Ron Johnson is just an absurdity. It shows a total lack of understanding of how power works in America right now and how politics is corrupted right now.
Adam,
there were some good points to Citizens United. Let me just throw in a couple good points about Citizens United, though, because Citizens United did say that we need more disclosure. Actually, Justice Kennedy was saying the antidote for all this outside money is increased disclosure. People should be able to know where the money is coming from. And so that was one of the good things. Another good thing in Citizens United was it drew a line between into so-called independent expenditures, these big expenditures by corporations or unions or other associations, and coordination with the candidate. This is an issue at play right now in Wisconsin, where the Wisconsin Supreme Court has said the First Amendment forbids the state of Wisconsin from banning coordination between candidates and outside groups. Well, that's just going to let corruption run rampant. And the justices in Citizens United were good on that question as well. But on the huge question of unlimited corporate spending in political campaigns, which have been outlawed for 100 years, now just gives corporations more power than ever to buy Congress and buy the White House and buy the state legislators.
Adam, a final comment before we move on to the next segment?
Well, Citizens United really was an important decision, but not just because it allowed corporations to spend more on electoral politics, but because on the basis of the court's rationale, subsequent courts have given individuals the right to spend unlimited amounts of money on electoral politics too, and made it clear that those independent expenditures, so long as they're not coordinated officially with the candidate, can be unlimited. And that's led to actually what we've seen since Citizens United, more individual funding, more really wealthy people backing, putting a lot of money into candidates than we have seen corporations. Where I think corporations are going to have one of the biggest impact, though, on electoral politics would be things like in state, local, county, municipal, judicial races, not necessarily senatorial races at the federal level, not presidential elections at the federal level, where there's already so much money. But in some of these smaller jurisdictions, you're going to see corporations, when they can make expenditures, so outspend their opponents that they'll really control democracy from the grassroots up, if you will, from the ground up, from these smaller jurisdictions.
Adam, you're absolutely right on that. It's happened already here in Wisconsin. You had the Koch brothers spending lavishly in way down ticket races, including the school board of Kenosha, Wisconsin. They knocked off a couple school board members who were opposed to Walker's policies on labor, and the Koch brothers are in bed with Walker. So they are willing to spend, as you were saying, way down ticket, and they can get a lot for their money that way.
All right, well, let me end this segment, and in the next segment, I want to talk about some of the pros and cons that have come from corporate personhood. We'll do that in a moment. Well, in the past, in the last section, we talked a little bit about the history of corporations and personhood. Now I want to talk about some of the real-world consequences. And as I was mentioning just before we came back, we've been talking about corporate rights, but concomitant to that, I think a citizen, a real-world citizen, me or either of you two, has a responsibility as well as a right. And it seems to me in the talk about corporate rights, corporate responsibility is often, a mile behind. And when I think of some of the big things like the oil spill a few years ago with the British Petroleum, or you can go back to Exxon Valdez, or any kinds of cases where there's corporate malfeasance, usually to save a buck, the idea of corporate rights is always front and center, but corporate responsibility is often sloughed off. And what can be done short of, say, capital punishment for corporations, i.e., revoking their charters, to get them to act, to bear the other 50%? They have the rights. Let's make them toe the responsibility. Maybe I'll start with you, Matt. What would a solution for you be?
Well, I do think revoking the rights is something that can be done and should be looked at in egregious cases. I also think when the chief executives or the senior executives are directly responsible for a heinous act, like the BP oil spill, if the chief executives were responsible for that, or the Massey Coal case, or Wall Street, the collapse on Wall Street, and the meddling and peddling of these ridiculous mortgages and derivatives from mortgages, that the officer should be prosecuted, and the Justice Department ought to do that, or district attorneys ought to do it, or attorney generals ought to do it. There should be some legal responsibility for those who are causing harm to individuals and the economy and the environment. So I'm hoping law enforcement will have a more powerful role to play. It's also shareholders could have a larger role. Shareholders could ask or demand at an annual meeting that before a corporation can spend a dime on any election, that they need to get a majority vote from shareholders. So, that may or may not work, because oftentimes the executives and institutional investors hold a majority of the stock, but at least it would require some system of oversight and democratic control on the political meddling that corporations do.
Adam?
Well, I guess we can think about it. If corporations are people, maybe they should start acting like people. They should start acting ethically, morally. It should be other regarding rather than selfish and profit maximizing. Then there's something to be said about that idea, to be sure. Although there's one huge difference between corporations and ordinary people, which is that corporations are legally created entities that are mandated by law to pursue the interests of the corporation, which is by most courts taken to be, at least in the long run, mean helping and advancing the financial interests of shareholders. Whether we call that maximizing profit or just pursuing profit, that's what corporations are designed to do, and that's what the law requires them to do. And so we shouldn't be surprised that these entities that are designed to create profit are not focusing their efforts on responsible behavior, socially responsible behavior. And that's not to say we don't ever get social responsibility. I think we've seen some really interesting examples of great corporate behavior in recent weeks. Just look at what's happened in North Carolina and in Georgia and these other states where corporations have really led the boycott in response to these transgender discriminatory bathroom bills. But why corporations are socially responsible in those areas is largely, again, because of profit. They think it's going to be good for consumers and for their workers to take these stands and think it's better for the corporate bottom line. I think we're kind of, we don't want to be praying for unicorns. And just the same, we shouldn't really be thinking that the corporations that we've set up to pursue profit are really going to be responsible human citizens the way you and I should be.
Does that mean that we should?
I agree with that. I mean, I don't think I'm not naive or thinking that they're going to act in any way that is socially responsible in general, unless it's part of their charter itself. And there are some corporations who are putting it as part of their charter. But it's all the more reason, from where I limit the amount of power that they hold, especially in the political arena, and to not ladle onto them more and more rights that in the Bill of Rights that weren't designed for them in the first place.
Is there a way that states, individual states, or federal governments, or national governments around the world could somehow better design a more streamlined, more specific charter that doesn't emphasize money making, but gives equal weight, say 50% to money making, 50% to corporate citizenship?
We have those forms already. That's not an unusual thing. I mean, we have nonprofit corporations. We have charitable corporations. We have educational corporations. There's all sorts of different kinds of corporations. Some are 501c3s that can just engage in educational activities like the NRA or Planned Parenthood or the Sierra Club. We've got corporations that are 501c4s that can be politically active and can spend most of their money on political engagement. But there's no tax exemption for the people who give money to them. We have benefit corporations that are increasing a new phenomenon where people are incorporating their otherwise profit-making businesses to also pursue public ends. So we have no shortage of business forms. The issue is just that the vast majority of corporations in America are business corporations in the old form that are really out there pursuing profit and are sort of legally required to. And it's something to remember that when people talk about corporations have free speech rights, corporations are never truly free. They're legally created. Their activities can only operate within the boundaries of legal mandates between what the law tells them and requires them to do, and that all corporate activity must be designed to pursue the long-term interests of the corporation. As a result, corporations are not really truly free in the sense that you and I are. You and me are? I don't know.
If
I are, I think, but
yeah, maybe I was right the first time.
This question.
Well, I wanted to ask about the ability for, say, average people who are in some way harmed by corporations to get some kind of legal remedy. And it's much harder. For example, if I were to attack Matt, or if Adam were to slander Matt, or if one of us did something in some criminal manner, broke into someone's house to thieve from them or whatnot, we would have legal remedies. But it seems to me, and maybe I'm naive or maybe I'm misreading it, that a lot of laws seem to give extra protections outside of just corporate personhood to people. For example, I mentioned earlier at-will work states, and I've worked for corporations. I've worked for big companies, small companies, non-corporations, corporations. I've worked public service, private sector. I've worked in unionized, non-unionized jobs. And a lot of the places where I work, there's the day-to-day kind of things that you see that are illegal, and I have been one, and there are people who have complained about some illegal activities. But if you work, at will or right to work state, for example, you're basically assigning away de facto, if not in terms legally, of giving away your right to sue if you are treated. Or let's say if you take an ethical stance, let's say if you work for a company that's poisoning the reservoir and you come forth with something, well, in an at will or right to work state, that person can be dismissed regardless of the ethics of it, unless, for example, they're a racial minority, a woman, or some other group that there's some provable bias against them. But simply taking an ethical stand, corporations are pretty much insulated from that. Number one, do both of you agree with my assessment? And if so, what would be remedies? Let me start with you, Adam, and then go to Matt.
Well, I think you point out something that's absolutely true, which is that corporations really aren't treated exactly like ordinary people in a whole range of different areas of
They're
the law.
almost like super people. They're almost like super people.
Right, in many ways, the law provides them additional benefits and additional preferences than individuals find difficult to obtain. And it's one of the interesting things. It gets back to something that we were talking about a little bit earlier, where we said, well, when I maybe provocatively called it a civil rights movement for corporations, one of the reasons why we think it's not a civil rights movement for corporations, or why we might chafe at that terminology, is that we do think that civil rights were expanded to racial minorities and women because they had been oppressed, and it was their effort to gain equal rights and equal dignity. And we don't see corporations as being oppressed. But one of the things that we find if we look back through American history is that corporations have actually used that same idea, that same argument, that they are oppressed, that they are disfavored in the law, that they are discriminated against, that they are essentially discrete and insular minorities. And they've used that argument time and time again in the Supreme Court and persuaded the justices to expand their rights because they are oppressed in some ways. And just the Citizens United case is a good example, where the court repeatedly called corporations disfavored forms of associations that face these special restrictions that no one else faces in the political process. And so the greatest trick the corporations have ever played is making the Supreme Court believe that they are an oppressed class too.
Matt, comment from you?
I've got to admit, I mean, that is the sleight of hand. That is the big trick. And the idea that corporations are disfavored, I think, though they can prevail at the Supreme Court with that argument on a common sense level, I think people understand across this country that corporations, but they're running the show, the economy, and they're increasingly running the political system, and that's been part of Bernie Sanders' popularity, and in a sense, a part of Donald Trump's popularity in saying that the political system is corrupt because, I was a billionaire and all these political candidates, I gave them all money and they danced my tune when I got the door. So people know the way the system works and how corrupt it is with corporations. I do think corporations are also insulating themselves by making people, especially consumers, sign contracts when they take a product so that they can't be sued further on. So they're isolating themselves and cordoning off the path to the courtroom as far as getting redress from people who've been disadvantaged or over by corporations. On the labor front, you mentioned, at-will workers and people being fired at will. And increasingly, there are more and more states that have the so-called right to work, including here in Wisconsin. But it should be noted that still today in 2016, in more than half the states of the union, you can be fired simply for being lesbian or gay or bisexual or transgender for no other reason than that. Your employer is a bigot. He fires you because the bigot, and that's okay under the law right now. And that's appalling. That is maybe the next frontier of the LGBT civil rights movement.
Well, let me, at the end of the interview, I'll give you both a few minutes to sum up your thoughts and whatnot. But I have two major questions that I'd like to sort of end this segment with. And the first one is, since corporations are collective entities, to what extent has the RICO statute been used against corporations? Because clearly, when a corporation does something illegal, to me, that's organized crime. That's every bit as much organized crime as the mafia or a terrorist group or anything else. So, if either of you want to just could give a little background, maybe I'll start with Adam on this one. If you could just explain briefly what the RICO statute is and how has it historically been applied in the few decades since its creation towards corporations, if at all?
Well, the RICO is a federal statute against racketeering and sort of criminal conspiracies. And the RICO statute has been used against the mob, for instance, collective entities that are engaged in criminal enterprises. Um, I'm not aware of too many efforts to use RICO against ordinary corporations that aren't somehow engaged in some kind of fraud in using the corporate form. But I may just not know about those cases better. But I do think one of the things that your question points out is that corporations are the subject to criminal prosecution. And I think that one of the things that gets lost in the debate over Citizens United and Hobby Lobby is that even if we want to take some rights away from corporations, a blunderbuss approach that would take all rights away from all corporations, such as some of the amendments that have been proposed for the 28th Amendment that would deny corporations any protections under the Constitution, would really be a serious mistake. And your question points out why, which is that corporations do need criminal procedure protections. If the government wants to charge a corporation with a crime, that corporation should have a right to due process of law. The government can't just take the money of a corporation and say, you're guilty of a crime and we don't even have to bring you before a court of law. Of course you do. Of course they have the right to counsel. Of course they should have the basic procedural protections that individuals have. But if we have an approach that says corporations have no constitutional rights, then they'd have no basis to challenge the use of RICO or really any government indictment against them in any way, shape, or form. So we have to be careful about how we think about corporate rights, and corporations shouldn't have all of the rights under the Constitution, but they also shouldn't have we also shouldn't have a system where corporations have no rights under the Constitution.
Matt, do you think that RICO is a tool that could be used against some of the more egregious corporate abuses?
You know, I thought about it during the banking scandal of 2007, 2008. Maybe there was some racketeering possible challenges there. Oddly, I thought it could have been used against the Catholic Church during the terrible acts of pedophilia by the members of the cloth that they were just shuffling around from one parish to another. That would have taken a great deal of courage on the part of any district attorney or attorney general. But that to me seemed like a possible prosecution. Oddly, it's a law topic, but it crossed my mind.
Well, let me then ask sort of the future of corporate personhood. Let me end the segment asking, since it seems to be that corporations globally and also in the West and the U.S. specifically have been gaining more and more rights, is there any danger, and this may sound sci-fi, in current parlance, people talk about artificial intelligence and robo-apocalypse. Is there a greater threat, do you think, towards human liberty, individual liberty going forward from, say, the granting or the gaining power of corporations than from, say, such a robo-apocalypse sci-fi thing? I.e., do you think that it's feasible that in the future corporations may become unmoored from their country's place of origin to the point that they become even more powerful than nation states and unaccountable to anyone the way nation states are? Adam, I know that sounds sort of sci-fi-ish, but I think it's probably more realistic than a robo-apocalypse.
I don't think what you're talking about is sci-fi. I think it's history.
Yeah.
It's already happened. We already have multinational corporations, and we've had them for a long time. We go back to the Dutch East India Company, one of the first great global corporations, and the British East India Company, which took over India many decades and scores and generations ago. So we already have that system in place where we have corporations that are expanding their power beyond the power of governments. And
well, let me, Adam, if I can, let me just, Adam, if I could. Recently, there was the case where it was tried to pass in the House of Representatives, I believe, so that people who suffer from 9/11 could sue the government of Saudi Arabia, and they're not subject to our laws. is there any chance that an American corporation at some point in the future could become so powerful that they become sort of extra national, like a foreign government? That's, I guess, what I was really getting at.
Well, I guess it's possible. I guess let me just say that I don't really know. I mean, I think we already have very powerful corporations that have used their power to gain immunity from state regulation in a variety of ways. Whether they'll be, completely deemed to be a foreign entity that the courts don't have jurisdiction over, I don't see happening largely because if you have operations in America, generally anything you do to an American citizen will be subject you to liability in an American court of law. So I don't see that happening, although obviously corporations are doing things and are unaccountable throughout most of the world today. And the American courts, just in recent years, the Roberts Court has made it harder to sue corporations for activities that they do in foreign countries that violate, for instance, human rights. So we already have corporations that are eluding immunity in a variety of more subtle ways.
Matt,
And one of
any
the ways
comment?
they are eluding immunity is through these international trade agreements. The World Trade Organization, NAFTA, CAFTA, the TPP that's on the drawing boards right now. These corporations are using these international trade agreements to avoid laws in the United States and other countries that want to regulate, for instance, use of GMOs or the use of or some environmental regulations or things like that, or labelings. And so, this is a real problem. Corporate power, international corporate power, they are already, as Adam said, unmoored from their nations of origin. We see them moving from one country to another for tax purposes and a whole range of other reasons. So the idea that a multinational corporation is a U.S. company is increasingly a wrong concept, because they are multinational through and through. And we need to get hold of corporations through our courts and through our electoral system. And I think through a constitutional amendment, I think it can be done in a way such that corporations are still able to sue and be sued and hold property in common, but that they won't be able to exercise the Bill of Rights that they are now trying to ascribe to themselves and succeeding oddly.
Well, let's end the segment there, and we'll end the interview in the next segment, just giving both Adam and Matt a final say-so. I've been speaking with Matt Rothschild and Adam Winkler about corporate personhood, its past, its present, and its future. Adam, if you could just take a minute or two just to sum up your thoughts, pro or con, on the subject overall.
Well, I think actually we kind of in some ways need to move beyond that pro or con story. The corporations are here to stay. We're going to have business corporations. They're not going to be fundamentally transformed, I think, in the near future. I think that we should think about these issues and try to reform corporations and use corporations for positive good. And that means in some ways recognizing that they are, by law, in some ways, people. They're not people like you and me. I don't mean to make that mistake. But being a person in the law means that you have legal standing. You have the right to sue and be sued, that you have some basic protections, and you're an independent, legally recognized actor. I think, 101, of course, every corporate lawyer learns that the first day, because that's why liability is limited, why you can't hold shareholders responsible for corporate activity, because the corporation is its own independent legal actor. So we should recognize that the problem isn't necessarily corporate personhood, and it isn't necessarily corporate rights, because corporations need to have some rights and have always had some rights, and the very basic purpose of the corporation was to have some rights. And so I think the answer isn't eliminating corporate personhood, and the answer isn't eliminating corporate rights, but taking a more nuanced approach that recognizes the corporation should have some rights, should be people for some reasons in the law, but yet not necessarily make the mistake that the Supreme Court has made too often, which is because they're people, giving them nearly all individual rights and giving them too much power and making them harder for we the people to control.
Matt, you seem to be less sanguine than Adam, so what are your final thoughts?
Well, I appreciate Adam's nuanced and thoughtful comments and insights on this issue, and I appreciate the opportunity to engage in this conversation. Basically, my concern is that corporations have way too much power in the United States. The huge corporations and banks have way too much power over our economy, and even worse, they have too much power over our political system. Jimmy Carter himself says we no longer have a functioning democracy. We have an oligarchy with unlimited political bribery. And then there was a study by professors at Princeton and at Northwestern that studied 2 decades of public policy and said basically what the people want, they never get. Unless, and the unless is if the biggest corporations and the elites want it, then the people get what they want. But only then. And that's not democracy. So we've got to solve our problem of this dysfunctional democracy. And that's why I'm in favor of a constitutional amendment that says corporations aren't persons, money isn't speech, and then we should take it from there. And I think we need to have something like that, with maybe some of the exceptions that Adam has pointed out here, so that we can really get to a situation where we have a real functioning democracy again, where people have an equal say in what happens in our country. That's what democracy is supposed to be.
Well, thanks to both Matt and Adam. Anyone who found their points interesting or stimulating, I'll have links to their web pages below this video. So again, thanks for your time and expertise.